you've been charged with a serious criminal offense. Let's say you've been charged with murder or aggravated assault, and the police will place you under arrest. They gave you an opportunity to speak to a lawyer, and that lawyer told you about your right to silence, not to speak to the police. But you want to get across your version of events stupidly. You didn't listen to the lawyer. So you sit down in the interrogation room and they interrogate you for hours, and you tell your version of events, and then later on, you're shocked to find out that that could be used against you in court. Not only what you said to them, but what you didn't say, or the inconsistencies between what you said to the police and what you said on the witness stand like 2 years later, what you're going to say. Anytime you give a statement to the police, no matter whether you're innocent, guilty, or somewhere in between, you're going to forget to say something, or you're going to say something inconsistent. It's never advisable to speak to the police after you've been placed under arrest, first and foremost. But what makes a confession inadmissible in Canada? And I'm not just talking about confessing where you confess a crime, but when you make a statement to the police about your involvement or lack of involvement, trying to explain your version of events. How does the Crown get that into evidence, and when is it not admissible in court? So let me break it down for you, and I'll give you an example. So first and foremost, in order for a statement that you've made to the police, whether it's a confession or just a simple statement, whether it's in the interrogation room, police car, or anywhere to be admissible, it must be what's called voluntary. And the Crown has to prove that you gave a voluntary statement beyond a reasonable doubt. And what exactly does that mean? Well, it's been defined by the Supreme Court of Canada in various cases. OICLE is one of the cases, a good case on point, and OICKLE. And these cases break down, first of all, it has to be, there's no threats, promises, or inducements to give the statement. Like if you're threatened by the police, say off camera or on camera for that matter, that if you don't give a statement, it's going to go worse for you, or they make promises. If you give a statement, we're going to give you a lenient sentence, or they induce you to give a statement somehow, improper inducement, like, this is going to help you if you give us, we'll give you a lighter sentence, things like this. That statement should be thrown out if you can show there's a reasonable doubt that that happened, okay? And sometimes they might say this off camera and deny it, but if they say it on camera, a threat, promise, or inducement, your statement's going to get thrown out. Now, the police, what they do, typically before you give a statement in the interrogation room, they give a caution that anything can and will be used against you. But even if, just because they give you a caution doesn't make it voluntary. There has to be no threats, promises, or inducements. That's the first point. Second point, there can't be a serious atmosphere of oppression. I'm going to give you an example. So let's say they have a person in an interrogation room who hasn't slept in a day. They got them in there 12 hours. They haven't given them food or water. They're breaking down psychologically, and they keep badgering and hammering them, overbearing their will. So it's not the proper voluntary mind. I've seen this situation too. They sometimes keep in them for hours and hours and hours improperly, young people, older people. That is potentially an oppressive situation where the statement could get thrown out and not used against you. Now, as well, if there's tricks used that would shock the community, that's another test as well. But the problem there is it really has to shock the community because the police are allowed to lie and use deceptive tactics. But at some point, tactics can become to the point where it shocks the community. Like, for example, in a Mr. Big operation, you've heard of those operations where they pretend they're a criminal enterprise undercover, bring you into the enterprise and get you ultimately confess to your original alleged crime. Well, that has to be proven to be reliable and voluntary as well, ultimately. And that's a significant test. But a lot of those Mr. Big operations get in. So you've got oppression, you've got voluntariness, and it has to be an operating mind. Like, for example, if someone's suffering from a mental illness, they're breaking down, they're emotionally distraught, their will has been overborne, and it's really not their operating mind, which is a tough test for the accused to show to create a reasonable doubt. But I've seen those cases too, where they're just breaking down someone who's mentally ill, giving a statement and saying all sorts of nonsense. So those are various factors that, just to recap, no threats, promises, or inducements, it has to be an operating mind, no oppressive circumstances, and no trickery that shocks the community. By the way, I don't know what shocks the community because it has to be pretty deceptive, and lies have to be up top, because I do another video that the police can lie. So that's, in any case, if the defense does not admit voluntariness, the Crown, before the trial starts, has to prove voluntariness. So they've got to call the police officers, play the video. The accused can potentially testify about what their state of mind was, and we see if there's threats, promises, or inducements, and the statement gets in. So it's a relatively easy test for the police, frankly. A lot of times they did trickery and deception, but it's okay. The person wasn't unduly oppressed, even though they might have been in there for hours, and they ultimately were voluntarily giving their story with a no threats, promises, or inducements. By the way, obviously, if the police are beating you in a separate room, if you don't testify, that's another case goes without saying. And unfortunately, that's happened in Canadian law too. They're not going to beat you on camera, are they? They're going to do violence in the other room. That went on a lot more in prior years. It's gotten a lot better. When I first started practicing law as a Crown in 1989, I can tell you there was a lot of that stuff going on. The police would ride up a person in an elevator, give them a few shots with a phone book. Okay, you're going to tell your story. But thankfully, we've got cameras everywhere, and this is much more difficult now. But you know, it probably still goes on occasionally, but it was a real problem in Canada in the early days when I started, and I heard crazy stories about 40s and 50s and 60s and 70s about crazy beatings by police officers. But that's a topic for another day. It's gotten a lot better, thankfully, in our democratic country. Now, what's the next way a statement or a confession? And when I say a confession, that's when you're admitting the offense necessarily, but statements could be your version of events that is inconsistent with the Crown. Like, I didn't do it, but do you really want to give that statement? Because when you give a 4-hour statement, can you imagine testifying a year later and trying to remember exactly the way you said it then? Because I can tell you this, I know I couldn't. If I'm an innocent person, there's no way, and people don't believe me when I say this, but I know, there's no way that you can tell the same version of events the same way every time, even when you're totally telling the truth, because you know the way memory works. You're going to forget something, you're under stress in that room. Do not talk to the police. Exercise your right to silence. But that's, when you get cross-examined by a clever Crown attorney who knows the business about your statement on the witness stand 2 years later at your murder trial versus what you said to the police, it's a disaster. They're going to create inconsistency, omissions. You forgot to say something. Oh my God, I forgot to say that. Why did I say this? Because you're under stress and you're human with frailties of human memory. Even if you're 100% innocent, I've seen it time after time after time. People simply don't listen to lawyers tell them right to silence because they think they can talk their way out of something, particularly innocent people, by the way. So be very careful. So what's the next way you can get a statement thrown out? Well, we have a Charter of Canadian Rights and Freedoms, and there's Section 10B. You have a right to retain and instruct a lawyer immediately upon arrest or detention. And the police, this is a very fertile area. The police often make mistakes in this area. There's so much case on this, I won't get into it. I'd go into it in other videos. But if the police make a mistake with respect to implementing your right to counsel or giving the information about rights to counsel, you can potentially throw out that statement under Section 24(2) of the Charter as against the administration of justice. So that's a charter application under Section 10B of the Charter to exclude under 24(2). Now, another situation is where your right to silence is not followed. That's a very much more difficult area. Under Section 7, you have a right to silence, but if they overbear that will of your right to silence and it's hard to get there because, you know, police are allowed to persistently question, and you can keep asserting your right to silence. But at some point, if the circumstances become so oppressive, it's mixed in with voluntariness too. So that's a fertile area as well. On occasion, I've gotten cases thrown out for right to silence. But yes, I've gotten many cases thrown out for voluntariness, but by and large, police typically follow the rules these days, fortunately. But the bottom line is you do not need to give a statement. There's no criminal accused in Canada who's placed under arrest who should ever voluntarily give the statement to the police. You're not helping yourself whether you're innocent, guilty, or somewhere in between. You're not going to talk your way to a charge, and you're not allowed to play that tape yourself at court. So what's the point? So if you don't say anything at that point and you take the witness stand, the Crown's not allowed to say, oh, you didn't tell the police anything. I mean, the judge would start screaming at the Crown. That's right to silence. You're not allowed to do that. So this is very important. These are the ways that statements are inadmissible in Canada. The voluntariness rule with Oikel and subsequent cases that we talked about with all those threats, promises, inducements, suppression, and of course, charter arguments under Section 10B and the right to silence under Section 7 if that's been totally not implemented, then you could win and get your statement thrown out and excluded. So there you have it. What's the takeaway from this really for the typical person who's facing a criminal offense? Look, you have a right to speak to a lawyer. The lawyer's going to be on the phone with you. The police have to implement that right. Talk to that lawyer, listen to their advice, and shut up and exercise your right to silence. So when the police bring you into that interrogation room, you say nothing. They'll talk. They'll keep, on a murder case, they'll keep asking questions and trying to get you chatting. Do not even chat socially with them. Just shut up. Every few minutes say, look, I'm exercising my right to silence, or I'm saying nothing. Just keep saying that till they give up. Eventually they'll give up. And they have all these techniques to get you talking. And a lot of people start chatting socially. It's a segue into them getting you to talk about peripheral things. It's a segue into them pretending you're your friend, lying to you, manipulating evidence, saying the co-accused is already giving a story. You better give your story. Maybe saying something off camera too if they're corrupt cops about promising you something. Just shut up. But I'll tell you, I bet you only 50% of people follow that advice and they regret it every time. I've had so many cases where people have received that advice and they just feel like talking because they think they can either talk their way out of it. They're innocent. If they're guilty, they think it's going to help them talking and they think it looks bad. It's not like going to the school principal. I mean, you get caught in the yard fighting and you go to your school principal and tell them what happened. It's not like that. Just shut up. Canadian law, a judge is not allowed to even consider that you didn't speak to the police. In fact, the Crown's not even allowed to lead that. So there you go. There's various instances of how a statement becomes inadmissible in Canada. If the statement's not admissible, it could be played by the Crown against you in court to prove their case or as part of their case. Or the Crown can also use it to cross-examine to show all the omissions and inconsistency, which are 100% going to happen in every time. I've never seen a person tell the same story the same way twice in a Canadian courtroom when they gave a statement. It just simply does not happen. There's even going to be, even a minor inconsistency or an omission is not going to be helpful to you. And people don't listen to me when I give them advice. They don't listen to lawyers, and they need to. And that's your right as a Canadian citizen. And especially when you're truly innocent, just shut up. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.